Okay, welcome everyone to the June 2019 myHRgenius HR Best Practices webinar series. Welcome to the presentation. My name is Kevin Mosher. I am going to be your host for this webinar this month. As we often do, pretty much every year, I think that we've been doing this webinar series, and I think we're in year 6 or 7. We've done over 6 years anyway. We're doing a mid-year legislative update. So much occurs these days, and so we in January we often do a kind of a prognostication and look back webinar, and then in the mid-year we tend to do a mid-year legislative update, just because so many legislatures are going, have meet in the spring, and I know obviously not every legislature, but a lot of them do, and then obviously at the federal level, the agency level, and the federal government level with Congress, that sort of thing. There's always stuff going on that we can definitely talk about. So anyway, that's what this is. So here's what we are not going to do. We are not going to talk about everything that has occurred. There are so many states that have things going on right now, between minimum wages and just all these various employment laws and rules and things like that at the city level, at the state level, at the county level. It's just really, there's no way that we can cover everything in 1 hour. So we're going to try to work on some bigger swath issues that are affecting multiple jurisdictions, multiple states, and certainly the federal stuff. We'd be here all day if we were to talk about, if I were going to talk about everything that's been going on in all the states. So as exciting as that would be for everybody to hear me talk about state and local laws all day long. This is me. I'm very happy in this picture, as multiple people have pointed out to me. If you are here on an invite and not a member of the myHRgenius program, this is a very unique program. I will just mention it before we start, but it's a very unique program where we have a legal hotline, and for $79 starting, you can call our attorneys with your day-to-day HR questions, and you don't have to worry about legal bills. So it's a really comprehensive program that we invite people to participate in. And for those of you that are on the call and that are part of the program, thank you. And it's hopefully you're really enjoying the program. It's a good value and benefit to your business. Today, here are some of the topics we're going to cover, but we're going to cover a lot more than this. So we are going to look at the new Department of Labor, Fair Labor Standards Act overtime rules. Definitely going to talk about that just because it's obviously, new, fresh. We've been waiting on these for years. We came so close in 2016, and then nothing happened. So we're gonna see about early 2020 if we have a new salary level test under federal law. And we'll talk about that in a minute. We're going to talk about the fantastic Social Security no-match letters, and I'm completely being sarcastic with that. The debacle, the annoyance, the confusion that is Social Security no-match letters, we're going to talk about those. We're going to talk about the NLRB. NLRB and the Department of Labor have had some updates as well, and then we're going to talk about some state stuff. There's been some stuff near and dear to my heart here in Minnesota, but also, we've seen some stuff going on in Massachusetts in particular with their new paid family medical leave law. And, so we're going to talk about that. We're going to talk about some medical marijuana as well, since that's kind of a developing topic from the last couple years as states have increasingly legalized medicinal and also recreational use of marijuana. Okay, so let's start with the Fair Labor Standards Act, minimum wages. So I think I was just going to mention the minimum wages rather than talking about it, just because it's really only specific to local jurisdictions, including St. Paul and the Minneapolis as well. So let's talk about the salary level, which is much more, widespread and important to people around the United States. So the salary level. So let's go back a little bit to 2016, when kind of toward the end of the Obama administration. This had been talked about well before 2016, but the Obama administration had implemented new regulations. It was about to implement new regulations right before the election, when a federal judge in Texas put a stop to the implementation, and that was going to raise the salary level for all white-collar exempt employees, not your commissioned salespeople, but your white-collar exempt, your administrative professionals, your executive professionals, and your professional exemptions, your learned professionals, learned and artistic professionals, was going to raise the salary level from what is now $23,660 or $455 a week to like $47,000 or something like that. So a little over $47,000, a pretty big jump, right? I mean, about twice as much in salary. So in order to claim the exemption under the previous Obama regulations, you're going to have to raise if you're going to claim the exemption, not have to pay overtime wages to the salaried exempt employees, then you're going to have to raise it up to, like about right around $47,000 per year. That got tabled. It got tabled, right before it was supposed to be implemented, threw everybody into a complete confusion on the issue. And so we then reverted back down, as though those regulations never occurred. We reverted back down to $455 per week. And that's where we've been. So we've been waiting, bated breath on this. We've been waiting for the Department of Labor to come out with something, and they have. So they are not, here's what the regulations are not. They are not going to completely turn over and the overtime regulations. What we really need clarification on from the government is the duties test. So you've got three tests, right, in order to claim somebody as being white-collar professional exempt. We've got the salary basis test, we've got the salary level test, and then we have the duties test. So in order to claim somebody, a white-collar exempt person, as exempt, you are going to have to meet all three. So these new regulations are not going to touch the first and the third. We are only looking at the salary level, and the salary level under the new proposed regulations goes from $455 per week to $679 per week. So that's going to be the new salary, the new salary level for your white collar exemptions, assuming that it gets implemented and not completely changed. So we will see what the final regulations look like, but right now it's looking like, if this gets implemented, that by early 2020 we are going to be having a $679 minimum salary level for your white collar exemptions. And then also for highly compensated, not a lot of people fall into the highly compensated level, which lowers the duties, the duties test and the salary basis is a little bit different there too, but we are looking at a proposed highly compensated level going from a pretty significant jump from $100,000 to $147,000 on that. The one thing that kind of gives is a little bit of a give to business, although honestly going to $35,000 is a pretty big give. I think there were some recent articles showing that basically the U.S. Chamber of Commerce was completely driving these regulations, which makes sense. Going from in today's economy, I mean most people, if they're professional and they're working in like an administrative or an executive or professional level, they're making at least $35,000 a year in most parts of the country. So it's not it's not going to be a huge thing that's probably going to upturn a lot of your businesses, though I suspect there will be some businesses in retail and hospitality where you're going to, where the compensation might have to rise up to $679 per week. But the proposal allowing non-discretionary bonuses to be able to compensate up to 10% of that salary. So, let's just say, if you're trying to meet the 35,308, you could use, 10% of that could come from non-discretionary bonuses that are paid out intermittently. So it's you don't have to exactly pay $679 per week. You can pay up to 10% less of that, as long as you're, making up that 10% later on, so that overall they make 35,308. So that's that. We will wait to see what happens in the future with that, and I suspect it's probably going to be implemented very similar to what it looks like right now is $679 per month. Predictive scheduling we have is an issue that is not yet, but I think predictive scheduling is something that we are going to see become a greater issue in the future. Certainly in the Midwestern states, West Coast to East Coast, but certainly at the if we start to see ordinance levels in the future. So what exactly is predictive? For those of you who are unfamiliar with predictive scheduling, what exactly is it? So as a concept, predictive scheduling is this idea that the government needs to step in to make sure that employers provide employees, normally non-exempt employees, but let's just call it non-exempt employees. The government needs to provide certainties to those employees so that they can understand what their schedule is going to be. So it's a way to plan so that non-exempt employees, especially lower wage workers, know that they can get daycare set up in advance. They can make sure that whatever things they've got in life are planned around. And so it puts a requirement that employers need to provide X number of days, normally like right around 7 days, advance notice of what the employee's schedule is going to be. So if you're in retail or hospitality or some other business and you're issuing weekly schedules and you're saying like, okay, this upcoming week, and you issue those schedules on like, let's just say Friday for the next Monday, and you're saying, okay, look, you're going to work Monday, Tuesday, Wednesday. Well, that's fine. You have to do it far enough in advance so that the person knows what the schedule is. And then you also need to, they're also restricted on the ability to change that schedule. So, and again, predictive scheduling, the rules around this just vary from location to location, the ordinance and at the state level now in Oregon. But the common thing here is that you have to provide minimum advance notice. And then if you change somebody's schedule, like day of, you need to pay them X percentage or X number of hours minimum for that shift. So if somebody's in the restaurant, is coming into a restaurant and they are expecting to work in an 8-hour shift, and there's nobody at the restaurant, and so they're sent home. This happens every day, right? So they're sent home and they're not paid, no tips, no hourly rate, wages, because they're hourly employees. Under these rules, that employer might have to pay for maybe the full shift, maybe half the shift, but is going to have to pay that employee for, let's just say, in some of these ordinances, might have to pay them for at least 4 of the hours, and they didn't work. So they provide no real benefit to the employer. But the ordinance is there to protect the employee, to say, hey, this employee came in, they got all dressed up, ready to go, and they came into work, they were there, they got daycare, whatever their situation, but they came in ready to work, you didn't have work for them, you sent them home, they didn't get any pay. No, we're going to step in and say you needed to provide them notice of that far enough in advance, and because you didn't, there's going to be, let's just call it a penalty, but you're going to have to pay them a minimum number of hours. This predictive scheduling, I wonder, I don't think we're there yet nationally as far as like a big national issue, because I think it is pretty limited to restaurant and hospitality. But I do think that in a lot of jurisdictions that predictive scheduling is going to become more widespread and is going to be the type of thing that a lot of employers in the country are going to have to deal with. And like I say, already in Chicago, is taking up this issue and might be implementing predictive scheduling in the near future in Chicago. We've already seen it in Philly. We've seen it in New York, Seattle. So there's a lot of, I mean, there are millions of people working, non-exempt workers working, especially in restaurant and hospitality, who are now, able to plan around their shifts much better in these cities. And Oregon, of course, like I had shown on the previous slide, Oregon passed at the state level for large employers. But Chicago was kind of the first one in the Midwest, is the first one in the Midwest to be thinking about this really seriously. Michigan had a law proposed several years ago. It didn't get too far in the legislative session. I think it's about 3, maybe 4 years ago, and I'm thinking about it. But Chicago would not surprise me at all if they take this up, even though there's obviously going to be a huge pushback from the restaurant and hospitality community, which is, in many ways, the workers there, the work that those businesses need is predicated on flexibility and not, needing to commit to, guaranteed wages for any sort of shift, just because, if there are no hotel rooms that are rented out, and nobody's showing up to the restaurant, why would you keep employees there? And so employers, so often want that flexibility. So I think it's something to look at, if only because it's spreading now, and it is so potentially devastating for restaurant and hospitality. I know a lot of you are not in Minneapolis or St. Paul, and so, but I want to talk about the Minneapolis sick and safety leave briefly, and if only because we just had a ruling come out from the Court of Appeals. And so, for those of you that aren't familiar with this, Minneapolis sick and safety leave is very similar to what Chicago has been doing. It's similar to what we've seen across the country in a number of jurisdictions where there's paid sick leave, right? So mandatory, and it's like the California model where they're earning it like 1 hour for 1 hour of paid sick leave or safety leave for every 30 hours of work. And the interesting thing is, and so in Chicago, when somebody, for example, under the Chicago ordinance, when somebody is traveling, through Chicago and they're working for a period of time in Chicago, I think it's off the top of my head 80 hours, but I might be a little off on that. But they're working a minimum amount of time. It doesn't matter where the employer is located. And they're going to, that employee is going to earn some time. Well, in Minneapolis and in St. Paul, there was a real question on this, and a lower court ruled that no, if you are an employer that doesn't have a physical premises within the city limits of Minneapolis or St. Paul, but the case is about Minneapolis. If you don't have a physical location in that city, say you're in California and you're sending somebody to work in Minneapolis for a client for, a couple of weeks. The court said you can't apply the sick and safety. We're not going to make you do paid time off, accrue paid time off for this employee where you don't have a physical presence within the city limits. And the court came back and said, no, that doesn't. We're not going to follow that rule. You don't need to have a physical presence. If you are in North Dakota or Illinois or New York or Texas or whatever, and you are sending employees to work up in Minneapolis, and they work a minimum number of hours, and again, I think for Minneapolis it's 80 hours or so as well, and they work at least 80 hours within the city limits, but the work is actually in the city limits in Minneapolis or St. Paul, then they're going to earn paid time off under this paid sick and safety leave as well. So it's out-of-state employers, metro area employers that don't have physical presences in Minnesota, in the Twin Cities, in Minneapolis or St. Paul, need to be aware of this if they're sending their employees, their non-exempt employees, to work in the city limits. No match letters. No match letters right now. So I've seen the numbers on this, and we'll talk about what the no match letters are. But right now, the government in 2019 has sent out about 577,000 of these no match letters to businesses. And so if you have not received a no match letter, that's great. The bad news is that a second wave is going to be coming later this year, probably in the fall. And so expect that if you have not received a no match letter, that you might be receiving a no match letter in the near future. And so, you know, I guess it's more incentive to actually pay attention to this if even if you haven't received it, because you very well might receive one in the second wave. So what exactly is a no match letter? And we've been dealing, you know, no match letters have been around for about 12 or so years under the current kind of form. And so what exactly is it? It is basically a notice being issued that the information that you provided, you as your business provided with regard to FICA to Social Security for such and such employee, let's call the employee, like, you know, Brian. So for this employee Brian, that the information that you provided with the Social Security number for Brian and Brian's name and everything doesn't match up with the information that the Social Security Administration has in their database. And so a mismatch is generated at that point. And you can tell there are a lot of mismatches, since 577,000 of these have been sent out already in 2019. So the letter is then generated. So they turned these letters off years ago during the Obama administration. They stopped sending these letters because what was happening is that Social Security was trying to fix their problem of having all these no matches, and they wanted to inform businesses of what the of this no match, so that the business could try to fix it on their end and try to fix the clerical mistake and maybe do a W-2C form, which is a wage correction form, notifying Social Security that, hey, sorry, fat fingers on this one, I put in the wrong Social Security number, I put in the wrong name, that sort of thing, and here, let me help you fix your database, right? Everybody's happy, Social Security gets a fixed database. But there are, if you haven't heard, there's a lot of undocumented workers in the United States, and millions, and they are, for the most part, using false Social Security numbers and identification for those employers that are actually, doing the I-9 and all that correctly. So, and reporting FICA. So these undocumented workers are out there and they're using false documentation, and so the false documentation should trigger a mismatch, right? So if I'm submitting to FICA wages, my wages under FICA for Brian, and I'm giving Brian's Social Security number, but then Social Security looks at it and they're like, well, hey, that Social Security number, that number belongs to Tara. Okay, so obviously, boom, mismatch. It doesn't show up. Now, there's a lot of reasons, like I say, clerical errors, there's a lot of reasons why this could happen, but for millions of these mismatches, it's because of the undocumented workers in the United States. So back in the day, back in like 2007 or so, when the government was first doing these no match letters and they just wanted to get everything fixed, they sent out these letters, and employers started to get it, and lo and behold, it's like it would list on the letter, it would list all the Social Security numbers. They don't do that anymore. They can't. There's a 2017 executive order prohibiting them from doing that. But so they would list all the Social Security numbers, and then employers would get that, and they'd look down and they'd see, like, well, this guy, this number's not here, this number's not here, this number's not here, this number's not here. And for a lot of employers, the remainder of the numbers were widely Hispanic employees, and so they would start to think like, oh my gosh, I just got notice from the government that I've got a bunch of illegal workers, undocumented workers, and I need to get rid of them. And so employers around the country were just like firing tens of thousands of Hispanic workers, and not always, justifiably. And so then they started going with different, like, oh my gosh, okay, well, we're not going to send out the letters. We're going to put some clarification language. The whole thing just became a huge mess in like, between 2007 and 2010, and that when the Obama administration came in and President Obama was like, well, we don't want, tens of thousands of Hispanic workers being fired without, almost smells of discrimination. So we don't want that. So they just stopped doing it altogether because these things just seem to be super confusing. But of course, the problem still exists, that the money is sitting out there, tens of billions of dollars is sitting out there in this mismatch fund that doesn't have anywhere to go, and the government would probably like to send it somewhere. So welcome 2019. The government last year announced that they were going to send out these no-match letters again in 2019. So they've sent it out. So they are notifying employers that you have a mismatch. So again, what are you supposed to do? There's instructions. It's kind of difficult to follow them. But if you get a mismatched letter, take a look at the instructions. You're going to have to log into a portal through the Social Security Administration, and then you're going to have to type in your login credentials, and then you're going to get a username and everything sent over to you that you can then use to see the Social Security numbers, and then you can look at your own internal records to see if the information that you reported to the government was incorrect for those. So it's kind of, allows you online to try to fix this, and then you file a W-2C form. So, but the question is, what are you going to do if you get the Social Security no-match letter? You give the employee, anywhere from 60 to 120 days to resolve it. You might tell the employee, like, hey, look, the information that I provided to the government matches with the information that you provided to the government. I'm going to need you to go to Social Security, the local Social Security office. So you then direct them, do this in a letter, direct them to go to the local Social Security office and try to fix the problem. Well, ultimately, in a lot of situations, the employee's not going to do that, maybe for whatever reason. It might be because they're undocumented. It might be because they just don't understand the instructions. It might be just that they're too busy and they don't think that there are consequences to this. So you're going to have to ask yourself, like, if the employee doesn't do this, they don't follow through, and I've continued to give them information and guidance to send them to Social Security to try to fix this, you might ultimately be presented with potential circumstantial evidence that the employee is undocumented in the United States because they have refused to go and try to fix this Social Security problem, and you've been notified by the government that there is a mismatch and that the information that the employee gave to you didn't jive with the federal government system. And so that's a potential problem that you might be confronted with, and it might result in you feeling the need to let the employee go. This all could occur despite the fact that on the letter itself, the letter itself says that you're not supposed to terminate anybody who's on the Social Security no-match letter. Well, that's all well and good from a Social Security standpoint, but there's ICE out there, and ICE does workplace enforcement, and just like today or so, the president's talking about rounding up millions, I assume it's hyperbole, but rounding up millions of undocumented workers, right? Or undocumented aliens. So, people who are working, a lot of them who are going to be people working in the United States. I don't see any of that actually occurring, but let's just say if it were to occur, if the government were to somehow be able to do that, round up millions of people, there's a whole lot of workers that are going to be exited from the United States. And ICE is going to be doing that. And ICE, if they come in and they do an audit and they are investigating you for hiring practices and to see if you're employing undocumented workers, well, there's a legitimate question there of what did you do with the Social Security no-match letters? Did you get those Social Security no-match letters? How did you resolve them in the past? And I think if you just sit on those and you don't do anything with them other than just tell the employee to go to Social Security to fix it, I think there's a potential risk there that ICE doesn't like that you just kind of shove, they might view it as you having shoved the problem under the rug, and they might have expected you to do more, and they might see that as circumstantial evidence that you are knowingly employing an undocumented worker in the United States, which is a problem for you, and it's a problem that, you probably don't have to lose too much sleep on this unless you're intentionally doing so. It's a problem that could result in jail time if you are found to knowingly be employing undocumented workers in the United States. Let's talk about paid leave. We already talked about the sick safety leave update in Minnesota, but we have a number of states and cities around the country that are implementing paid. So we've got paid sick and safety leaves, which is like paid time off to be sick, but then we also have paid family leave, which is basically just saying, like, if you're, a lot of these laws are basically saying if you're basically meeting the criteria of FMLA, of family medical leave, then we're going to pay it, or we're going to pay some percentage of your normal wages that you're missing out. And so we see that. We definitely see the sick and safety paid time off in a number of places, including like California. But then California, for example, also has the paid family leave on top of it. So they have, like, paid time off, then they have the paid family leave, and the paid family leave tends to be more of like your bonding type of situation where you want to bond with a new child or an adopted child. And then we have the new one, the big one, I think. Say the big one, as if it's, well, one of the big ones is that's hitting the news a lot lately in the last couple of days is in Massachusetts, where Massachusetts has the newest paid medical leave law, and I think the next slide will deal with that. But at the federal level, we have multiple potential laws that have been out there for a number of years, few years anyway, and that get pressed periodically, but right now Congress doesn't seem to be behind any one in particular, and probably because Congress is broken down politically by parties, right? So we've got let's just looking at the three like headline proposals that are out there. They're all a little bit different, and so we've got the Ivanka Trump and the Marco Rubio, that's called the New Parents Act. And this is one that's the most divergent from what we're seeing. So most cities and states, we see something like I was talking about in Minnesota, where we have, like, and in California, where you earn like 1 hour of sick and safety leave for every 30 hours of work, right? And in some, I think Chicago off the top of my head, it's like 1 hour for every 40 hours worked. And so we see, in a lot of states, we see this like 1 hour for every 30 hours worked. The other framework is to be more like more on the paid family medical leave side of things, and for bonding, where it's more like an insurance policy, which is what they have like in New York, and they now are implementing in Massachusetts. And it's more like an insurance program where you're going to pay payroll taxes into this fund, and then from the fund, once you hit the criteria, the eligibility criteria, and let's just say you have a baby, then you can petition to the government. You file a claim, basically, and then you receive a percentage of your lost wages back through this insurance type of policy, like kind of like short-term disability if you're on FMLA, but through the government and through payroll taxes. Well, the Ivanka and Marco Rubio plan is different than that, right? So that proposal is to basically front pay your earnings from Social Security, which sounds great because it's not like Social Security is going to be around probably anyway. So might as well take it when you can get it. So that proposal is to say, look, if you're a new parent or adopted parent or adopting a child or have a new child and you want time off work for bonding, which sounds great, then you could borrow against your future Social Security earnings and get some payment. So it's great. I mean, I think there's definitely some value in. I mean, clearly there's value in having parents take some time off and spend it with their children. Dipping into Social Security seems to me like overly complicated, and I don't think Social Security probably needs to be more complicated than it already is, and underfunded. So anyway, I don't think that the Democrats definitely are not on board with that whole New Parents Act proposal, but because the Republicans are in control of the Senate, you've got Ivanka Trump who likes to speak on this stuff. That is still out there, and a potential law. And then you've got the Working Parents Flexibility Act, which is more of like a tax incentive type program, kind of like your cafeteria type of programs that might offer some sort of savings account that you could set aside for taking time off. And then the Democrats are pushing more of that framework that I was talking about in New York and the new one in Massachusetts, where you do some sort of payroll tax at the federal level, though, some sort of payroll tax, and then you could apply for benefits, for lost wage benefits from the whatever agency would be controlling it. And then here's a slide with some more detail on the new Massachusetts, the Massachusetts Paid Family Medical Leave Act that is set to start. It was set to start on July 1st, but it just got pushed back a couple days ago. So we're going to start technically with the program on October 1st, and that again is going to be one of these payroll tax frameworks where, and New York did this as well, where they start with taking away from they start collecting the money months in advance before they actually start doling out the benefits. So here too in Massachusetts, just like New York did it, you're going to collect a 0.75% payroll tax. That's going to cover sick medical leave as well. That's where most of the money is going to go, and then the employees will start to be able to apply for the benefits starting in 2021. So if they need personal time off for bonding or for active duty leave situations, they can start applying for it, but they're going to start paying for the program beginning October 1st of 2019, and then it'll be fully like up and operational on July 1st of 2021, where then employees can start asking, getting reimbursement for the care of a family member with a serious health condition as well. And so after July 1st of 2021, it'll be up and running, and we'll see. But right now it's been delayed a little bit, and employers in Massachusetts have to provide notice of the rights and all that to the employees in that state. So it'll be interesting to see how this rolls out, but it should be similar to what we've been seeing in New York the last couple of years. Minnesota, I mentioned this only for those of you who are in Minnesota, just because I am here and it's a beautiful day and everything, and I figured it would be nice to just bring up Minnesota, because Minnesota is looking like a lot of states. So Minnesota is very similar to a lot of states looking at these two frameworks, and Minnesota is looking at this same type of framework. We've got the California, where we've got earned paid time off, looking at it at 1 hour for every 30 hours worked. And then Minnesota also in this last legislative session, though neither of these passed, was also looking at doing the insurance type of framework like we just explained in Massachusetts. And like I say, I think if you're in a Midwestern state, if you're in a West Coast state, and if you're in an East Coast state, and if your state and you have employees in those states that haven't implemented either of these paid time off frameworks where they're earning, based on the number of hours per week of work, or you're in a state that doesn't have this payroll tax that's creating an insurance reimbursement program, I think it's coming. I think this is just pretty low-hanging fruit for a lot of advocacy groups. Terrible. I just couldn't say that. Groups out there, and so I think that
it's coming if it's not in your state as well. One thing I want to mention, and again, because Minnesota looked at this, and Minnesota is kind of toward the front end of what we're seeing nationally with the Me Too movement. Minnesota looked, and the big thing under federal law is that when we look at harassment, Title VII lawsuits under federal law, we normally win those by showing that the employee was not subjected to severe and pervasive treatment that affected, term or condition of employment. And this is the key, this is the crux to a hostile work environment claim. And Minnesota, for the Minnesota Human Rights Act, tried to water what is harassment down by taking out this severe and pervasive requirement. And I will just tell you that a lot of times on these sorts of social advocacy in the employment sector issues, Minnesota and California and Massachusetts are kind of the three states where they try these sorts of laws out. They try these changes out to see if they can get them passed and how much bipartisan support they can get. And if it can pass in Minnesota, they'll often take it on the road and try it in Illinois and California, and same with Massachusetts and California as well. So these are like test ground states for these changes in the law, and there's a lot of momentum behind this change to take away severe and pervasive. And I will just say, it didn't make it, so it died in the Senate. But I will just say that if it passes in Minnesota, it could be floodgates opening in other jurisdictions around the country, and this would significantly increase the amount of litigation and the risk that employers have to harassment and hostile work environment claims. And so it's worth watching, even in a small state up north in flyover country. It is definitely worth watching to make sure that that this does not happen, in my opinion. Okay, so this going to the Supreme Court and back to the federal level here. One of the issues that we're going to find out for the Supreme Court, and it's an issue I've talked about a bunch over the years, is does Title VII prohibit sexual orientation discrimination? Can you discriminate under federal law against people based on their sexual orientation? And for years, decades, the answer was yes. That just like you can discriminate, we talk about protected classes, right? And the question is sexual orientation a protected class? Now, under a lot of state laws, in fact, I think it's 22 states, 23 states, prohibit it. So in those states you can't, and there are a lot of people living in those states, so a lot of the country, probably well over half the country, population-wise, you cannot discriminate based on somebody's sexual orientation. But in the remainder of the countries, it's an open issue whether federal law protects us. So for those of you that don't listen to the podcast, I know everybody wants more opportunity to hear my melodious voice, but we did our first podcast exactly on this, and if you have never heard of the podcast series, we're just starting out, and it's you can go and get it on iTunes or Google Play or Spotify or Stitcher under my HR podcast, and or on our website at myHRgenius.co. And we did our first one on this exact issue. And so the Supreme Court is taking this up. The EEOC flipped several years ago under the Obama administration, and they came out and said that they felt that Title VII, that they were going beyond the exact language of Title VII, and that they were saying, no, sexual orientation discrimination is akin to sex discrimination, and therefore it's a protected class. But clearly, not every jurisdiction believes that, and I think that's an open issue. So we will find out, I think, this session from the Supreme Court whether sexual orientation is prohibited under federal law. And I think the Supreme Court's going to say no, but we'll see. I've been wrong a number of times, but my guess is that they will get a strict interpretation of the Title VII, and they will say that it does not say anything about sexual orientation discrimination. And if you want more on that topic, you are welcome to listen to the 9-minute podcast that we have on it. Okay, NLRB. Let's talk about a couple important. The NLRB's had a couple important decisions, advice memos that have come out. One is on if anybody has ever experienced or seen the fat cat blow up cat thing that unions use, and then also the rat. Those are Scabby the rat. Those are symbols that unions use all the time to indicate that, fat cat, indicating that the employer is stealing wages to the detriment of its workers, right? So making all this money, the fat cat making all this money on the backs and the sweat of its workers. And then Scabby the rat, basically being out there, warning people about being scabs, about crossing picket lines and working for certain employers. And so those have been allowed the last 10 or so years by the NLRB, but now, and basically under the Obama administration, the way that they were interpreting what is picketing, and so they are having a narrower definition of picketing, saying that it wasn't picketing to use the fat cat or Scabby the rat. And so in a recent decision from the advice memo from the NLRB, the General Counsel opined that a broader definition of what is picketing, and therefore what should be restricted under the National Labor Relations Act, should be interpreted going forward, and found that the use of fat cat and Scabby the rat were picketing and potentially unlawful. And so hopefully this will result in fewer fat cats and Scabby the rats all over the United States, which to me is a good thing. But yeah, unions got away with way too much stuff with regard to the use of those inflatables. The other thing, the NLRB gave a big win to the gig economy about a month or two ago, and said that basically looked at a company that's very similar to Uber. It wasn't Uber. It was like a company that basically provides a platform through an app where homeowners can hire handymen or handy people to come in and do work on their house, or plumbers or something like that. And so the NLRB looked at that and they said, hey, is that an independent contractor or is that an employee? And it's a big question for employees in, for independent contract workers in the gig economy, because if it's an employee, then like Uber has to claim these people as employees, and this company at issue in this advice memo needs to claim the person as an employee. But the government came out and said no, the real employer, the real potential employer is the homeowner, not the company that sets up the app, even though the company that sets up the app collects all the money and creates the framework around the compensation and all that. They said that's just incidental to it, that when you're hopping in the Uber, you are directing the driver where to go. You are the employer. Like, that Uber driver is working for you for that short time period, or you're directing the employee who's coming in to fix your plumbing. And so that was a pretty big win, because it's been out there for quite a while, and the gig economy is so reliant upon independent contractor workers, that it was just a big win from the Trump, with the Trump administration to get a ruling from the NLRB saying that people working for Uber or for others in the gig economy, that they're not employees. Department of Labor has also similarly delivered some wins for employers in the last few months, or in 2019 here. So favorable decision, we got a good one from the Department of Labor looking at, they're issuing advisory memos right again, which is great. And so they came out and they said, look, the Obama administration, the Department of Labor for the Obama administration, they were looking at the whole, at this question of what is economic dependence when trying to determine who, is the person an employee or an independent contractor. And economic dependence is the big question, right? And so we look at the factors of control, permanency of the relationship, the investment in facilities, and skill, initiative, judgment, opportunity, and then how integrated the person is into the workforce. But what the Trump administration looked at is they looked back and they said they looked more at control. And while they all recognize that these are the factors, they looked at similar situations that the Obama administration had looked at, and they found that these are more likely to be independent contractors. So it's just kind of looking at the same set of circumstances and weighing the factors, like the control being a little bit more important of a factor for the Trump administration. And so if the company is exercising less control, and some of these other like skill initiative and all that are out there, it's going to, under the Trump administration, the Department of Labor anyway, it is more likely to be an independent contractor than it would have been under the Obama administration. So I think there's a little bit of a sigh of relief there, because we've finally gotten some guidance from the Trump Department of Labor that they are not going to be strictly looking at a narrower definition of who an independent contractor is. Other issue that's kind of been out there for a while of interest is, what do we do with employees who are on FMLA being unpaid, and they are taking a number of short breaks? Maybe they have seizures, maybe they need to go and take some sort of medication for their disability, and they have to do it like 4 times a day for like 10 minutes or 15 minutes each time. And so the Department of Labor made it clear that if the person's on FMLA, they can take short amounts of time on FMLA without it being called a paid rest break, because the Fair Labor Standards Act says if it's a 20-minute or less break, the person really can't relax, so you should be paying them. And so there's always kind of been this question of, well, okay, but what if it's FMLA? Like, you were supposed to pay them because the person can't rest, but then we've got a certain medical certification for the FMLA here saying that they don't need to be paid. And so, the Department of Labor came out with this opinion letter and said, no, if they're on FMLA, even if it's a short break, you don't have to pay them. You could take 15 minutes, 10 or 15 minutes or whatever they're spending doing their medicine or dealing with their seizures, whatever it is, on FMLA. You could take that out of their wages and call it FMLA and count it against their FMLA time. Another joint employer factors as well. The Department of Labor, I don't want to get too deep into this, but the Department of Labor gave a favorable joint issued a favorable joint employer test regulations that we will see how it plays out. But basically looking at these factors, the business can hire or fire the employees, that's what they're going to look at. Whether the business controls the worker's schedule or conditions of employment, whether the business determines the worker's pay rate, methods of payment, and if the business maintains the worker's employment. Under these regulations, these proposed regulations, again, we'll see what it looks like in the end, but it seems like you're going to have businesses are going to be able to claim that they're not joint employers a little bit more readily than they currently do under the way that the Obama administration had been interpreting. So joint employers was an area that we saw a lot of movement under the Obama administration on finding that there are joint employers, and then we're hoping that moves in the opposite direction with these new proposed regulations. We'll see what they look like. New forms. We have a new EEO-1 form for those of you that are covered by the EEO, that are large enough to be covered by the EEO-1. You hopefully got your Component 1 report in by May 31st. That covering the fourth quarter from 2018, and then the Component 2, which is the bigger one that's newer because for the Trump administration had tabled the need for employers to report wage data for its employees, but now we have to do it again because the federal judge is like, why aren't you doing this? And your reasons for not doing this are not credible. So we now have to do it. And so September 30th, employers are covered employers are going to have to report under these 12 pay bands for their wage data across their all their locations. Right now, last I saw on the website, I think it's been a couple days since I checked, but the department, the EOC, had not yet published the pay band data. So I think that's coming in the near future. It's supposed to come in July sometime. So you're going to want to check that out before you submit and get the resources from the EOC. So that's definitely coming in the near future. And then also we have a new Form I-9 that is coming. And then this week, I didn't put a slide in it, but just because we had enough slides, but just wanted to mention that Minnesota, just the only real major legislation that the state of Minnesota passed was with regard to this Wage Theft Act, and so employers in Minnesota now have a number of requirements regarding policies and getting and notification to new employees, new hirees of various things with regard to their pay and paid range and that sort of thing. So we'll be doing tips of the week on that for Minnesota employers, but just heads up, if you have 1 or 2 or 1,000 or 10,000 Minnesota employees, you're going to have to look at complying by July 1 with this new Wage Theft Act, which is very different than what I've seen in a lot of other states with regard to wage disclosure and other paperwork requirements. So thank you so much for your attention and time on this. I really appreciate it. Look forward to presenting next month. If anybody has any questions, you're welcome to email me directly at kmosher@thompsoncode.com or call at 651-389-5007. Wish you well, and we will connect with you next month.